Hello and welcome to Sunday Funday from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Thank you guys so much for being here. I'm calling it a Sunday morning because it's morning time where I'm at, but I realize that some of you it's just hit noon, and for others of you it might even be the evening, depending on where you live in the world. But wherever you're at, thank you so much for being here on a Sunday. I think this is going to be a lot of fun today. It's going to be a lot of fun because of you guys, and I'll explain to you why in a moment. But on these Sunday shows, we usually get a lot of new viewers, people who may not have seen the channel before. So I wanted to take a quick moment to just introduce who I am so you know where I'm coming from. My name is Joshua Ritter. I was a prosecutor in the LA District Attorney's Office for 10 years. I left, and now I've been a defense attorney for nearly as long. So I try my best to bring you both sides of every issue with as much experience as I can possibly bring to the table. So thank you all for being here. Hello to everybody in the chat, B Michigan and Lee T and David Guagamela and all of the familiar names, Michelle Salter, Tio Toys, Disney Nerd 85. Love you guys for being here. Jen St. Pierre, you're all amazing. Here, I'm going to ask you first. I have to ask this, as is obligatory in YouTube law, that you hit the like button and subscribe to this channel if you haven't already. That helps us let the algorithm gods know that we're here and available. But we have some fun things for today, because the big announcement that we have is that we hit 20,000 subscribers. And I got to tell you, I'm blown away. Not my wildest dreams. Thank you so much, Afton. Did I think that we would be at this point as quickly as we have arrived here? It is mind-blowing, and it's encouraging, and it's exciting. And I'll tell you what, it gives us, the Courtroom Confidential team, so much energy and renewed enthusiasm to continue to do this, knowing the positive feedback that we're receiving from all of you by your support. So thank you, thank you, thank you. Thank you, Miss Kitty, for the congratulations. So here's the plan for this morning. It will be, we've got some updates on some news. Sean Diddy Combs received what's called a new indictment, but that's not the technical term for it. Sorry, I'm not sick. I just have a frog in my throat. He received a superseding indictment that we can go through. Marilyn Manson was being investigated for sexual assault related charges. He's been cleared of that. We can talk a little bit about that. That was a new announcement. But happening yesterday in the Ellen Greenberg case, with some really fascinating news, with a affidavit received from the original medical examiner on that case that may entirely tip this entire thing on its head. So that is kind of the updates that we have. But first, what we've got for you are, we've asked you guys to please leave us voice messages, because part of what we want this show Sunday to turn into is answering your voice messages live on this stream. And we feel that it will be a fun way to kind of interact and get to know each other. And so we really bugged you and pestered you and said, you know, get past your nervousness and leave us a voice message. And you guys came through. Thank you so much. We have a bunch of messages to get through, and they're all excellent, excellent questions. And because it's not beneath me to bribe you, we have a giveaway that we're going to give away to one of the folks that left us a message. So stay tuned for the end of the when we get through the end of the messages. I will announce who that is, and that person will be taking this home with them, which is the metal tumbler of Courtroom Confidential, one of my favorite items that we have on the store. Okay. And give us questions along the way. I don't ever want to stop you guys from asking questions. So if we're talking about a subject that you've been curious about, you go ahead and jump right in, and we will answer questions along the way. All right. First, let's get to these calls. Tell me if you guys can hear this clearly as I begin to play it.
Hi, Joshua. First thing is I love your show. I'm pretty new to it, but I am digging it. The next question I have is I'm curious as to why all of these old cases, um, like from 2019 forward, I guess, you can say, are taking so long to try. I've just noticed it a lot, and I was wondering the reason for it. And my thought was maybe it's because of COVID. So let me know if you know or your thoughts. Thanks.
Great question. And the name that I was shown here on our app is Tisha. So I hope I'm getting that right. Great question. And you are correct to point out that it seems to be starting since 2019. And then you did the math and figured out that COVID likely played a role. The answer is yes, COVID played a big role in that. COVID, for the first time in the history of our country, we were not the first time, pardon me, for the first time in a long time, we were suspending due process rights. Just think about that. They felt that it was such a national security and safety issue that they essentially suspended the rights of the Constitution. You have a due process right to a speedy trial and to have certain, things done, evidence turned over, informed of what you're charged with, all these types of things. And they suspended that. They put all of that on hold. In California, in addition to what the Constitution says, they have written into their own Constitution laws on how long this should all take. If you are arrested, you have 10 days to go to prelim, 48 hours to go to arraignment, 10 days to go to prelim, 60 days to go to trial. These are things written in stone, so important that if those deadlines are blown, the case will be dismissed. There are cases where prosecutors could not get their case together in time for one of those deadlines, and the judge will dismiss that case. That's how important they are. Yet, during COVID, during the lockdowns, those were suspended, and people were just either languishing in jail or put on some sort of house arrest, and their cases just trailed on. So, yes, COVID had a huge impact on all of that. But you will find that some cases just seem to take forever anyways. Other cases seem like they're fast-tracked to trial. I'm thinking of the Simpson case out of Texas. Seems like it's already heading to trial. Who knows if those dates will remain in effect. But other cases just seem to drag on. Koberger, for instance, seems to be dragging on now. We're going on close to 3 years since the time of those murders. And that has to do with a lot of the jurisdiction where it's taking place, just kind of what pressures they have on their own court system. The particular judge, I mean, I've been working in Los Angeles for my entire career, and I know that some judges will give you plenty of time, and other judges are squeezing you to get to trial within, the first or second setting. A lot of that has to do with the complexity of the case. If there's reams and reams and reams and reams and hard bytes and terabytes of discovery, the judge is going to give the defense plenty of time to go through all of that. And then the seriousness of the case. If it's a death penalty case or an LWOP case, it likely is a lot of deference is going to be given to the defense for how much time they need. But the end point is that a lot of that, aside from COVID, depends on the defendant. And the only thing they're really in charge of is the clock. And if they want more time, they're usually afforded it. And if they say, I want to invoke my speedy trial rights, depending on the jurisdiction they're in, they will get their speedy trial rights. When I say depending on the jurisdiction, like I said, in California, it's hardline rules. And I have a buddy who practices in Tennessee, and he's like, yeah, speedy trial kind of means something different out here. So it really does, though, fall into the hands of the defendant. But excellent question. Thank you so much. All right. Question number, or voice message number 2 here.
Hi, Josh. This is Gina Gilmore, a transplanted Texan, now an expat in Mexico. And I'm a religious follower of your YouTube channel and just love it. And I watched the episode on the upcoming trials, the top 10. And I was wondering, what trial or which trial are you looking forward to the most? Which one do you think is going to be the most interesting, particularly in terms of breaking down legal issues and drama? Thanks.
Great question again. I love that, Gina. And I want to hear more about your story of how you're an expat living in Mexico. And if you need legal advice, go ahead and contact me. But that's a pretty interesting background story. So thank you for calling. Thank you for sharing that little bit of info about you. Great question too. The 2025, I don't know if it's that I'm paying attention more or if it just the stars have aligned, but 2025 is shaping out to be one hell of a year for criminal trials. And there's a lot that I'm looking forward to. A lot of cases that we don't talk about a whole bunch that I find to be fascinating. And then a lot of those, headline making cases that everybody seems to be anticipating. Obviously, I think Karen Reed part 2 is going to be interesting. I know a lot of people have Karen Reed fatigue, and that's understandable. I'm looking forward to it because retrials can sometimes be more interesting from kind of an inside baseball perspective. In other words, what are the parties going to do differently this time around? How has kind of animosity grown and tension grown between the sides? How will witnesses handle their cross-examination now that they've testified a second time and it may have been a third time and they may have their police report? That's an interesting case for me. The other Karen says, I've heard competing answers on this question. If Karen Reed appellate decision does not come down before April 1st, will trial proceed? The answer is I don't believe that Judge Cannoni is under any legal obligation to hold off on the trial pending the appellate decision. But will she be running into a buzzsaw if she starts the trial and then the appellate decision comes down in the middle of that and somehow affects the trial? Absolutely. So she's got a very important decision to make. But I am trying to think if there is some sort of, and this might be above my pay grade, some sort of law preventing her from doing that. I have not heard her saying she is stopping this freight train. She is starting April 1st, and that seems like every decision she's made since telling them that seems like where they're headed. Great question, though. Another case I'm looking forward to, for obvious reasons, is Brian Kohberger. I just think it is so rare to find a case that is just so nightmarishly horrific. I mean, that was one of those cases where when you heard about what took place, you almost kind of remember where you were. I mean, the idea of 4 students being stabbed to death as they slept, one of them survived, didn't know what was going on. They didn't have a suspect for weeks. I mean, it was just one of those cases where you're like, does this kind of evil still happen today? And it really kind of caught my imagination and fascination. And I think it's also going to be an interesting case. Now, it's going to come down to a lot to deal with DNA, but this defense team is coming in swinging, and so I think they will certainly put up a fight. That's another case that I'm looking forward to. But the case that I think presents the most interesting issues, and I'm curious if you guys agree, to me is Corey Richins. Corey Richins, I do not feel is as clear cut as everybody may think it is. I know that a lot of people are like, oh, she's just clearly guilty. And I'm not saying that there's not a lot of evidence to support that. But this case has got a lot of problems that either are going to get hashed out or they're going to present issues for the prosecution. There were Miranda issues of when they were interviewing her, whether or not they should have advised her of her Miranda rights. There are Fourth Amendment issues about certain warrants that were executed and things that they found during those warrants that they shouldn't have seized and they did anyways. There are issues with her Sixth Amendment right to counsel. When the law enforcement is being informed she's got an attorney, don't interview her, and they're still trying to interview her, that presents problems. There's issues regarding the walk the dog letter about attorney-client privilege and work product privilege and all of these things. There it is. Kaylin, once again, Kaylin just quick on the draw. I love it. So a lot of issues in this case leading up to it, which are the stuff that really fascinates me. I think you guys appreciate this probably more than most folks, but a lot of lawyering is done when the cameras aren't on. It's done in pretrial. It's done in all these 402 in limine evidentiary hearings. That is where the landscape of the entire trial is going to take place. That is where you decide all of the important issues, all of the important watershed moments, and then the trial is just kind of that all playing out. Sometimes there's a surprise. Sometimes there's a twist. Sometimes there's a gotcha moment. But for the most part, it's all everybody kind of following a script and trying to do their best with that script. And that script has been determined by all of these other issues beforehand. If you want to know who's a really good trial lawyer, then you watch the lawyers who are doing well in these pretrial motions and the motions that they're bringing, the arguments that they're making, and how they're creating the landscape of that trial. Yes, they have to be good in court. Yes, they have to think on their feet, but really all of the snazzy lawyering in the world can't undo the failure to make a pretrial motion ahead of time. So that case is fascinating to me. I think she's got some arguments, and I think the prosecution's got some problems, and it's going to be a fascinating case to see. So thank you again so much for that question. I'm looking forward to that one. What are you guys looking forward to? Let me know, because we want to be able to also provide you with coverage on those cases. All right, let's move on to our next. Alicia. Oh, did you guys hear that? Oh, shoot. All right, let me see.
Alicia K. Mayo from Tennessee here. Many happy congratulations on 20,000, y'all. Joshua, T-Suze, Kaylin, Nightmont, everybody. Looking forward to 50,000.
Alicia, you are my spirit animal, and from your lips to God's ears, I appreciate the congratulations, and we're looking forward to 50,000 too. Thank you very much. All right.
Hey, Joshua and the Courtroom Confidential crew, especially you two, Kaylin and Tiffany. We know who's powering this growing juggernaut. My name's Mandy. I'm a huge fan. Joshua, you were my favorite guest on Anna Garcia's podcast, and then Sidebar was my favorite add-on. You can imagine my delight when you started this show. My husband, by the way, less delighted. You were my gateway drug to true crime. So I now follow all of the folks you've either guested on their shows or you've invited here for your chats or your conversation series. So he calls all of these my murder tutorials, and I don't correct him, honestly. It's a healthy fear, builds character. Anyway, I have two questions for you. One, what was your least favorite class at law school? And two, why was it Civ Pro? Just kidding. The real question, Joshua. I know you have a lot of these because, none of us become successful without them. But what's one case that you look back on and think, damn, yeah, if I knew then what I knew now, I'd have handled it differently. And why? Was it some legal or procedural detail you just didn't yet have in your arsenal, or was it more that you just didn't really understand yet the nuances of like human juries? Anyway, thank you for all your awesome content. Happy Sunday Fun Day, CC Crew. Bye.
Mandy, you're wonderful. I appreciate that so much. All the kind words, and you've been around. You're an OG. You've been around for a while, so I appreciate that. And I especially love. I have the image of when you say murder tutorials and your husband watching. I have the image of you sitting in front of your computer watching YouTube, and then taking notes while you shoot him a side eye now and then. So keep that man on his toes. Great questions. Thank you so much. What was my least favorite class in law school? To be honest with you, I think it was property law. It's funny. I think that students either hate property law or they hate contracts. I loved contracts. And it really comes down to contracts is almost like math. It's like if A plus B, then you get C. Whereas property law, literally the way they refer to it is that you have a bundle of rights. And I always thought to myself, is that the best metaphor you could possibly come up with? Is a bundle of rights. In other words, here's a mess of laws that you have to learn, and we don't know how they connect to each other. And it's also really old and archaic and has these archaic terms, easement, running with the land. I don't know. I'm getting it all wrong. I've forgotten all of it, I'm sure, but it was the most confusing and difficult for me. And I remember when I had a property law question on the bar, I just tap danced my way through it as best as I possibly could. And the great thing about the bar exam is you have no idea which questions you failed on and which you didn't. So I'm just going to tell everybody I passed that question with flying colors, even though I may not have. How did you feel about securities in corporate law? Not a big fan either. I obviously was a big fan of criminal law. I really did like contracts. I found that to just be kind of easy to wrap my head around because it just, everything seemed to have a point counterpoint. Yeah, all of the other kind of in the weeds Civ Pro stuff, I just didn't get into. Criminal procedure was fascinating, learning about people's rights and everything else. And then I liked all the trial advocacy and everything. I guess the universe was telling me from the very beginning what kind of a lawyer I should have become. But the other part of Mandy's question was, is there a case I would handle differently? And that I love because it's a very introspective question. And I have two answers to that question. There are two cases I would have handled differently. And they're my first and last case I've ever handled. My first case trial as a prosecutor was the fastest not guilty I ever received in my entire life. Literally, when I was done with closing arguments and they had instructed the jury, they went back into the jury room and they buzzed immediately with a question. And I hadn't even finished putting away my file. I hadn't even gathered up my items off of the desk, and they had a question. And their question was, this was on a Friday, if we don't have a verdict today, do we have to come back Monday? Which was not a good sign for me. We sent them back an answer saying, yes, you do have to come back if you don't have a verdict today. And within minutes of that, they buzzed twice, meaning they have a verdict, and they came out and said not guilty. So they were already pretty much had made up their minds. And the reason I would do that again is because I learned an incredibly valuable lesson from that. First of all, I learned that it can't get worse than that. I can't possibly lose that quickly again. So everything was going to be uphill from there. But it also helped me to realize how to really analyze the strength of a case. I went into that thinking, oh, okay, well, this isn't the best, but I'm going to argue this and I'm going to argue that, and I'm going to really pull this together. And I had this kind of, pie in the sky, you know, full of piss and vinegar sort of mentality, and I'm going to go out there and kick butt on this thing, when I really should have looked at it and said, this is absolute hot garbage and we need to dismiss this, and we never should have filed this to begin with. And that case taught me a lesson about that. That's something I probably would have done over. And then the last case I ever handled as a defense attorney, and that was earlier last year. And right before we started this channel, or right as we were starting this channel. And it was a very long and complex fraud case. I was defending a gentleman, and I really feel that he was, I think he was wrongly prosecuted. I really do. I think that the prosecution was very myopic in the way that they treated the law. And I don't want to get into the details of it so much. I think they had it all wrong. And I think they were falsely accusing this man. And I really do believe that. The problem was, in order to adequately defend him, we would have had to spend tens of thousands of dollars on experts to explain it all. And he simply did not have the money. So I did the best that I could with the resources that we had and put on the best of our argument, and he was convicted. And this man's an older gentleman, and he went to prison. And it breaks my heart, because I feel like this is one of the sad parts about our system, but it's absolutely true. Money still plays a role in all this. As much as justice should be blind, you cannot argue that money doesn't play a role. And had he had the money to go out there and hire these experts, and we were able to put on an unfettered case, a limitless case, I think we would have won the day. But you know, it is what it is, and it's a sad situation sometimes. Not often, but sometimes. Thank you, Mandy. Great question. All right, moving on.
Hi, Josh. It's Damaris from England. I have so many questions. I'm really trying to narrow them down and cut down on the waffle. So today, in the Karen Reid trial, I was listening to Hank Brennan arguing as to why Judge Canoni should allow a Daubert hearing for Richard Green. And even myself as a layperson, I know that the purpose of those hearings is to decide only as to whether this expert really is indeed qualified to be an expert. And as I'm listening to Hank Brennan, I'm realizing why people don't like lawyers for the first time ever, because he seems to skate very close to the line of what is ethical in his trying to circumvent the process. And I wonder whether the reason that I'm noticing these things, like I noticed there was a lot of issues in the Delphi case, and you know, this Karen Reid case is just astounding to me. And whether or not I'm being shocked and surprised by behavior of judges and lawyers, because I'm just not used to the process. And is it because we're seeing so many of these things on being televised now that we're being exposed to it? Or is this what it's really like, that you really do have to fight in a sort of gladiatorial way to get through the legal process? And I hope that makes sense. I'm sorry for my big waffle. Love your channel.
Damaris, again, thank you so much for the call. Appreciate hearing from you, and hello to everybody in England who follows this channel. Great question. Wonderful question. You guys asked the best questions. To the first or the second part of your question, you know, like anything in life, you're going to have bad actors. You're going to have a bad egg, and you're going to have overly zealous people, and people who, and you call it gladiatorial is, I think, the term that you used. It's an adversarial process, and people naturally, as much as they try to do the right thing, when it's an adversarial situation, people get dug in, and sometimes that leads them to doing the wrong thing in the pursuit of winning, right? I'm not saying that's happening here, but I'm saying that might be what you're experiencing with watching some of these cases. Two, like I said, I've been doing this for so long and seen so many trials that I've myself been a part of or watched, and you just realize some are good and some are bad. Some judges are fantastic and others are absolutely awful and don't belong on the bench. Some attorneys are the most ethical and others bend the rules as much as they possibly can. And it's just like anything else. But you bring up a really interesting point about this Karen Reed Daubert hearing. And so I'm not going to get into what the judge should do, what is happening in this case exactly, but I do think it's good opportunity for us to talk about exactly what is being challenged and what are the issues here. Daubert has to do with, in its simplest terms, weeding out junk science, okay? It's the idea that there should be certain factors or hurdles in order for a science to even be presented to jurors. And that has to do with things like, can the technique be tested for reliability? Is the science subject to peer review? What are the potential rates for error in this type of science? Are there standards that exist for this science? Is it generally accepted amongst the scientific community? Daubert was dealing with the idea of, we can't just all of a sudden start introducing these kind of harebrained junk science things into trials under the guise of this person being a quote unquote expert. That even to testify on a specific topic, you have to pass certain tests of reliability. Okay, that's really what Daubert's about. In tandem with this is the concept of an admissibility of an expert. So now you've said this science, this area of expertise is something you're going to allow. Will you allow this particular expert to testify to it? And this all kind of each state and each jurisdiction kind of has their rules on it, but they all basically derive from the federal evidence code rule 702. Okay. And the factors there are, does first this expert specialized knowledge, is it helpful to the jury? In other words, you cannot present an expert just on any old thing, especially things that are maybe common knowledge. If you have a jaywalking case, you're not going to present an expert on what is a red light and when are people allowed to walk and what is the average speed of a walking person. People know about jaywalking, okay? That doesn't help them to bring in an expert, and it in fact might confuse the issues, okay? So you have to first decide, is this an area of law that is something that having an expert will be helpful for the jurors to arrive at their decision? And in this case, we're talking about data extraction of a cell phone. Absolutely, that is something that would be helpful to a jury. They cannot decide for themselves. You cannot just hand the jury the raw data and expect for them to understand what that data is saying. And this all comes down to that phone, that Google search of, how long to die in the cold at 2:27 in the morning. Did it occur then or didn't it? Having an expert explain the data extraction of the phone to determine that is very important. Shy Gal says, by doing this, isn't he questioning the judge's original decision? And I think what you mean is, isn't the Commonwealth attorney asking the judge to revisit the decision that she made in the original case? Yes. Is he allowed to do that? 100%. This is a new trial. It's anything's open. Everything is open to question. Everything is open to challenge. This is a brand new trial. And if things weren't challenged before and they want to challenge it again, they absolutely can. Now, the defense is making excellent arguments and saying, Judge, you already allowed this. Why are you going to go back on it? And it's an interesting strategy by the defense. But I think Cannoni is one of those judges to say, it wasn't challenged to me before. These arguments weren't made to me to be before, and I'm going to make those decisions based upon this trial. Anyhow, the other factors are is the evidence, is the expertise going to be based upon sufficient facts and data? In other words, you can't get an expert up there to testify when they don't have enough information to give an opinion. We're not going to just let them render opinions on scarce evidence. Is it based upon reliable principles and methods? And this factor is what the Commonwealth focused in on a lot. They felt that Green was not basing his opinions on reliable principles and methods, that his methods were flawed and therefore shouldn't be allowed. And then the final factor is that the expert's opinion reflects a reliable application of those methods and principles. Okay, so it's really those last two factors about what they're saying in the simplest form. What the Commonwealth is saying is this person shouldn't be allowed to testify, not really because of their expertise, but because their methods and principles are not reliable enough. And we'll show you why. And because they're not reliable enough, they should not be allowed to be presented to the jury. Now, experts have differing opinion. It's not about that he's got a different opinion. Experts, I mean, this is the battle of the experts is a time-tested trial tactic. It happens all the time. Experts have differing opinions. But I think something important to understand the Commonwealth's argument here is that there's a difference between, and I'm not using this term properly, but it's the best way for me to describe it, between hard and soft sciences, right? You've got, you've got experts on blood spatter experts who can take a look at the pattern of blood spatter and try to tell you, what does that say about how the person was injured? Where were they standing? Where did the blow come from? All of those types of things. You can have an expert who says, I interpret this way. You can have another expert who can say, I interpret it a different way. That is a open to interpretation type of expertise. Medical examiners. You will hear a medical examiner that say, I believe that the person died of asphyxiation. And you'll say another person, expert say, well, I've taken a look at that same autopsy and I believe that they died of blunt force trauma. Yes, they were asphyxiated, but the blunt force trauma caused them to bleed out sooner. And these are things that are open to interpretation. And therefore, both experts should get up, give their reasons, and allow the jury to assess whose theory is more believable. But then there's other stuff that are more kind of hard science issues, like measurements, okay? If a body is on the floor and you say that that body was located 6 feet away from the wall, that measurement is not open to interpretation. You're not going to have a person come in, one expert say, it was measured and it was 6 feet. And another person say, well, I view measurements differently. And my assessment of the measurement was that it was actually 9 feet. Okay. That's not what we're talking about when we're talking about open to interpretation. But what if you came in and you attacked the tape measure? Okay. Now follow me. And I hope this metaphor is not getting too convoluted. But what if you say, I believe that the tape measure used to measure the distance from the body to the wall was flawed. And that tape measure was off by a foot. And so therefore, when they measured it and they said it was 6 feet, they were wrong and it was actually 7 feet. And I'll explain to you why their tape measure is wrong. Now we're getting into an area that I think is similar to what's being argued here. The Commonwealth is arguing that, listen, this search took place at 2:27 or it didn't. We all agree on that, right? That there's only two interpretations of this, that it took place then or it did not. And you would expect that phones, given their collection of data and how it all works, there should be absolute answer to all of that. So why do we have different experts giving different opinions on this? And that is because the methodology being used is different. And the Commonwealth is calling into question the methodology of the defense expert. And so really it comes down to, it's not that we don't feel he's qualified as an expert. It's not that we don't feel that he's able to talk about these things, but the methodology that he used is so flawed, and we can show to you why it's flawed, that therefore you shouldn't allow him to testify to it, because by allowing him to testify to it, you're allowing flawed information to come in front of the jury, and the jury will be confused. Those are the arguments. Will they carry the day? I don't know. I believe that Canoni already came out and said she doesn't need to have a further hearing on this. So it sounds like she may have made up her mind and will give us her ruling to come up shortly. And I think likely, if I'm a betting man, she'll allow him to testify, because she'll say, listen, I am not going to make myself an expert on all this stuff. And instead of me deciding whose methodology is more reliable, that is really a question for the jury. So defense, you would go ahead and put on your expert and have him explain his methodology. And Commonwealth, you go ahead and put on your expert. And if your expert says that his methodology is bad, that's a question for the jury, not so much for me as a judge in deciding admissibility before the jurors. I think that's how it'll end up. But great question, Damaris. I appreciate you as always, and thank you for bringing that up. All right. Anything on that? Did I miss? I feel like I'm just carrying on without hearing what you guys have to say on some of these cases. Akasha says, do we think the prosecution is just fishing for information before the trial? You know, I think there's some of that happening too. I think that it's, I don't know if I would call it fishing, but I think they're certainly trying to nail down some of these arguments and get some of these experts on the record as to what exactly they're going to testify to. I believe that that's absolutely what happened with the defense's dog bite expert. That with that doctor is eminently qualified to give that opinion. That doctor has tremendous experience, has seen hundreds of dog bites. If she wants to say that's a dog bite, I think she's qualified to give that opinion. He may disagree with that opinion. He may have another expert who disagrees with that opinion. But this is, again, falls into one of those soft science, open to interpretation situations. But what I think he knew he was going to lose that. But I think, and I could be giving him more credit than he deserves, but I think he was maybe being stupid like a fox and wanted to put her on the record and get her to be specific about what she's going to testify to, so that he could then hand that transcript over to his experts and say, do the best that you can with this. Again, that's why Karen Reed's going to be a fascinating one. We're all experiencing Karen Reed fatigue, but I still think it's going to be an interesting case. And, you know, you've got my buddy, Alan Jackson's going to be back in court, and I know you guys are all big fans of him, so we'll watch that case together. All right, moving on. Let me know if you can hear this one.
Hey, Josh, this is one of your members. My name is Michelle Salter, and I live in Wenatchee, Washington. And a couple of things. First of all, my compliment to you and everyone that is assisting you with your channel. It is a fresh and polished channel and approach to all of us true crime watchers. I really enjoy it. It is really adding a nice variety to the platform for legal true crime content. And then my question is in regards to juries being able to ask questions. We've had a couple of trials that the jurors have been able to ask questions, and I wonder what you think about that, and if you think that that should be something that should be done across the board, whether it be a civil case, a district court case, a criminal case, and have that be across the board with all of our counties and states. And that was my question. And I'll look forward to Fun Day Sunday. Thank you.
Thank you, Michelle. First of all, thank you for those very kind words. We are trying to do our best to be fresh and polished over here. And so, with our ragtag team, that we managed to pull it together. So big shout outs to Kaylin and Tiffany for everything that they do to make this channel what it is. And so thank you for the compliment. Great question. Great question. First, let me say this. Where I practice and when I was coming up as a prosecutor, the idea of jurors asking questions was unheard of. That's not done. And so there's this, mentality of you're trying to figure out what they're paying attention to. You're trying to figure out what they're interested in. You're trying to figure out which way they're going as you're doing the trial. And you're doing a lot of observing the jury to see whether or not they're taking notice of important points or not. But you are in a complete dark room when it comes to actually knowing what they're thinking until the end of the trial. And then you start to get these questions when they're back in deliberations, and the questions always knock you out of your seat because you're like, what are they doing back there? This is really their first question, and it always seems to infuriate you. So it's foreign to me. But if this whole process is about coming to the truth, and if this whole process is about explaining to jurors what happened and having them decide what are the facts and evidence and therefore was a crime committed, then you would think we would want to answer their questions along the way. So I think my answer to that is yes, if it's done the right way. In other words, we talked a lot about, in a previous question, the landscape of the law, right? And the landscape of the trial. So I know jurors, naturally being curious, are going to start asking questions about things that they can't have an answer to. And instead of just telling them we can't answer that, I think a way in which it was like, we encourage you to answer questions and we will answer those that we feel appropriate, and not letting them know along the way if those answers are going to be answered, those questions are going to be answered or not, might be a better way of doing it, rather than reading the question and telling them we can't answer that, or reading every single question and trying to answer every question. But it is, I think, a great insight to both the prosecution and defense as to what the jurors are thinking about, what's important to them. I'm thinking from the prosecution side, especially if you've got them asking questions about some element that you felt was kind of a given, then you need to lean into that element. And the same for the defense. If they're asking questions about something, you might know how to pivot your strategy. So it is good as long as it doesn't, if they don't start to kind of control the trial and turn the trial into something other than what it should be. I hope that makes sense. The universe of the trial is not the same universe outside of the courtroom. And there's a lot of information we don't let them know about. And there's very important rules for why we don't let them know that. And it seems to me that they always start asking about those things they shouldn't know about. And are we doing more harm or good by telling them they can't know about that? That's kind of just my concerns on it. But again, Michelle, fantastic question. All right. Moving on. Oh boy, don't fail me now. Come on. Okay, tell me if you can hear this.
Hi, Josh and Tiffany. Congratulations. Much love from November, Mass. Have a great day. Bye.
That was from Donna Barnes, one of our longtime members and subscribers. Thank you very much, Donna. It's very sweet to hear from you. All right.
Congrats on 20,000 subscribers, Josh. I'm Les. I'm in British Columbia, Canada. I'm interested in knowing what happened to the lady in Georgia that was being charged because her kid went to the store without her permission. It may be something they've already covered, but if I missed it, I'm sorry. But again, congratulations. Love the podcast. Keep it up.
Thank you so much. You guys heard that, right? Thank you so much, Les. Appreciate you being a listener from Canada. And Les brings up this case that we talked about a while ago. It was a woman by the name of Brittany Patterson. There's Brittany and there's her son. And Brittany, her son at the time was 10 years old. She was at the doctor with another one of her children, and her son took it upon himself to walk to the store and back. And it was less than a mile to the store and back. And some neighbor, someone called the police and said, I see this kid walking alone. And the police went out to her home and arrested her and charged her with child endangerment. And their quote was that for failure to provide a child with adequate supervision necessary for such child's well-being. Here's the picture of her being arrested in front of her own kids, by the way. A story that got a lot of attention back when this happened. It was around Halloween, and then the story kind of made a bunch of news in November. And to me, I was just kind of shocked and appalled at the overreach here. That, nobody was saying the kid was in danger. Nobody was saying that that this is a bad mother. She's obviously a caring, loving mother, and she gets arrested for letting her kid walk around. Okay, we could spend a lot of time talking about this case alone, but it raised a lot of questions about what is the crime here. Are you not allowed to let your kids? What if you have very independent children and you're trying to teach them how to walk around? Are we just saying that our streets are so inherently dangerous that no child can walk on them? I used to walk home from school when I was in elementary school. Were my parents committing crimes? And at what age is it okay? This kid's 10 years old. I mean, I could understand if we're talking about a 3-year-old, a 4-year-old, but a 10-year-old. Again, really kind of shocking stuff. Then to add to that, I think they kind of realized that they had overreached, and they told her they would drop the charges against her if she put a GPS tracker on his phone so that she could follow him. First of all, not a horrible idea for any parent, right? Just to kind of know where your kid is at. I don't think she's opposed to that idea of protection and knowing where her kid is at. But she said, by doing that, I would be admitting what I was doing was wrong, and I'm not going to do it. I'm not going to accept that. And so now it's back in the hands of the DA's office. And last time I did some research on what has happened since the last time we talked about this. Last time what's happened is she went on the Tamara Hall show, received a lot of support from that. We learned that the town she lives in is called Mineral Bluff. It's a town of 300 people. This kid wasn't walking down the street of Detroit in the middle of the night. He was in the middle of the day walking through a town of 300 people. People that routinely children walk to their neighbors' homes to play with them. They get on their bike and, be back before the lights turn on, kind of a situation. Absolutely maddening. But to answer your question, Les, the DA has not made a decision. This took place in October. I imagine they fall under a 1-year statute of limitations. I imagine there's a lot of hand wringing and people just pulling out their hair and trying to decide, how do we get ourselves out of this PR mess that we have built for ourselves here. Did I miss a question there, Kaylin? It's a case that if we have further updates on it, I will absolutely give you guys the updates, because it's a case that really bothers me. It's a case that I feel like, part of prosecutors' jobs is to decide which cases not to charge. And this is one where they did not use the right discretion. Afton says, was there history with this family or something? No, not that we have. I feel like we would have learned that by now. And no, it sounds like she was a very loving, committed mother. It wasn't like this kid was constantly, out being a juvenile delinquent or something like that. He was just walking to the store. One other thing that we know about this is that it was without her permission. He didn't ask. He just walked to the store to get a snack or something. And again, it comes down to, well, what is she supposed to do? Chain him to the wall while she's gone? The kid left. The kid's fine. He's got a loving home to be a part of. It's not like they were starving at home and he had to go out and fend for food. Again, it's just drives you nuts when you see this kind of overreach. All right. Moving on. Are you guys hearing that? What do I keep doing here? Hey. Hold on. Here we go.
Tennessee, y'all. This is Alicia K. Happy Friday night from warm and lovely Tennessee, y'all. This is Alicia K. Mayo. Since I already left a voice message before the giveaway was announced, and again, many major congratulations to everyone at Courtroom Confidential for hitting 20,000 subscribers. Yay. But you got to ask a question to maybe win that very sharp-looking 20-ounce stainless steel tumbler that has the straw and the lid included. Okay, here's my question. Are y'all going to pick my name to win that tumbler? Seriously, though, y'all are my favorite YouTube channel. How quickly nearly a year has flown by, and I hope everyone is having a happy Sunday fun day. Thanks. Bye.
Alicia K., you are fantastic. Again, you are my spirit animal. I appreciate you so much. We're going to find out Tumblr's on at play here. We're going to find out the winner soon enough, but thank you, Alicia, for all your support and for just putting a smile on my face. You are absolutely fantastic. All right, moving on.
Happy Sunday, Courtroom Confidential. Hi, crew. It's Sonia in Chicago. All right, I have two questions. The first one is, Josh, if the ASAP case comes back as not guilty, will that hurt a civil case? I noticed, as many have, that Ben and Camilla had been in court. I'm wondering if they are changing their minds with this witness testimony. All right, the second one is, being an LA defense attorney, secretly I've always wanted to be one. But anyway, is it like they do in the movies? Do they call you in the middle of the night saying something happened, I need a lawyer, or when the cops are banging on the door? How and when do you normally get involved? And is it as exciting as it is in the movies? All right, thank you. Bye.
Thank you so much, Sonia. Again, a wonderful question. To answer your second question first, sometimes it is. I'm not going to say it's like in the movies where it's just, one fast-paced moment after the next. A lot of being defense attorney can be mundane and filing paperwork and answering phone calls and everything else. But when things do happen, sometimes everything happens incredibly quickly. And it is funny because I remember more than once, I would be thinking to myself, this is going to be a boring week. I'm going to get caught up on a bunch of other work, whatever. And it would that's when lightning would strike. And yeah, sometimes it is a middle of the morning. Usually, it's bad when you're getting a call from a client or the client's wife more than anything. And it's early in the morning. When you get a 5 a.m. phone call and it's the client's wife and you answer it and she's in tears, you already know what's up. The FBI's at the door. He's in handcuffs. They're taking him off. What do I do? And it is sometimes, then it is, you got to drop everything you're doing. You got to head out to court. You've got to be, here's the thing about the type of law I practice is a lot of it does not care about your timeline. When a client gets arrested, they're going to be in court for arraignment in 48 hours and they expect you to be there. And you may have plans in that 48 hours and they don't care about your plans. And it may involve you traveling, and it may involve you hopping on a plane, and it may involve a lot of run up. And then all of a sudden you were floating along thinking that you had the next 2-3 weeks with, maybe take some time off, maybe you catch up on other work. And all of a sudden now you have this incredible monster of a case dropped right in your lap. And these are people who need help. This is not a situation where people can be told, well, can I handle this later? They're calling you at their most dire time. Their life is in complete shambles. They are behind bars or looking down the barrel of the federal government or state government or whatever it is, and they are at the worst of their worst and they need your help. And so, yeah, that can be fast-paced and that can be exciting and that can be stressful. And then, it's in between those times, it's moments of absolute boredom. It's kind of like baseball. Like it can be, 20 minutes of boring and nothing's happening, followed by 30 seconds of absolute frenzy and excitement. So that's what it's like. And very stressful. Kraken Studio says, defense attorneys, in my opinion, are proxy therapists to 100%. So many of the calls that I take from clients are not about legal stuff, are not about what's happening next with my case. It's just you all of a sudden become an incredibly important person in this person's world. And I tell clients that a lot, that when they're like trying to decide what attorney am I going to choose, and I'm one of the ones they're trying to decide, I say, I don't care who you hire, but you better like this person, because you're going to be with that person for the next several months of your life, making some very important decisions and calling that person to help you through these difficult times and just kind of comfort you. And it is a lot of being their therapist, bartender, shoulder to cry on, dealing with it. White Sox baseball or Dodgers baseball? Great question, Afton. It's, of course, Dodgers baseball, who have, by the way, made some incredible moves in the offseason. So next season should be really interesting to watch. So thank you for putting a smile on my face just to think about that. But the other part of your question, Sonia, was to do with ASAP Rocky and the civil case and the criminal case and how might they affect each other. So Camille Vasquez has been hired by ASAP Relly to represent him. And Camille, became famous and we all fell in love with her because she represented Johnny Depp in his defamation case. She is the plaintiff representing ASAP Relly in a defamation case against not only ASAP Rocky, but Rocky's attorney, as we see right there, Joe Tacopina, for defamation. And it's for a bunch of comments that they made up to this trial. He's a liar. He's in it for the money, all of this type of stuff. Two issues here to really think about this. One is what was said in the lead up to trial, and can that expose Tacopina and ASAP Rocky to defamation? And two, what was said during trial and in relation to trial. First of all, during trial, I don't think they have a small snowball's chance in hell of getting a defamation suit. In the defense of your client, it is not only allowed, but expected that you're going to be calling the accusers of them liars. You're a liar. You're full of it. You're motivated by other things. To hold back from that for fear of defamation would be anathema to what a defense attorney does. So they are nearly shielded from any kind of thing that they say in court. Now, they cannot say, when did you stop beating your wife? When they know there's absolutely nothing to support that, just to muddy that person up. But even then, bringing a defamation suit in that situation would be, I think, difficult. But what about the statements that they made before trial, not in trial, not during cross-examination? And that, again, I think is a little murky, and it's curious to me as to why they hired Camille Vasquez. I imagine she's not cheap anymore. Not that she ever was cheap, but I imagine her fees have gone up. And why hire her for this defamation case? Because, again, in defense of your client, and if you're giving a press conference in relation to what you expect to prove and argue at trial, I think you're given a lot of wiggle room and leeway. So saying things like, this is all made up. He's a liar. My client never shot him. He wants to just get money. Calling that defamation, I think, is a real stretch. But to Sonia's ultimate question, if ASAP is convicted here, will that make the defamation suit stronger? I don't know, but it certainly couldn't hurt. But it will certainly make a civil lawsuit for injuries and damages related to that far more easy. Many times, civil cases shadow and follow the criminal case, and the second they get that conviction, they ask the court clerk, "Can I please have a printout of that order of the verdict?" And that's exhibit number 1 in their civil suit, because they can admit it and say, listen, another jury has already decided beyond a reasonable doubt that this person committed the same thing that I'm accusing them of here in a civil context with a much lower standard. But as far as defamation goes, maybe if he's found guilty, they could go back and say, now a court of law has found that they don't believe these accusations against me. But again, the defamation thing to me just seems bizarre and misplaced and kind of a little bit of noise. And I don't know if it was just PR stuff and maybe she's representing him for the civil suit, and he said, well, if you're going to do that, I demand that you bring a defamation case. And she said, if that's the price of admission, that's fine to me. I don't know. Don't tell anybody that's actually true, but this is just kind of my suspicions on this whole thing. All right. Let's go on to our next thing here, and I'm going to make sure that we don't have any issues with our speak pipe. Let me know again, guys, if you can hear this.
Hi, Josh. This is Holly, and I'm in Houston, Texas. I don't know if you remember me. You said hi to me back a couple times whenever y'all were interviewing Chris and Karen McDonough. I love them so much. They are so sweet, and they have such a great channel. And but I was already subscribed to you from Gizella at Grizzly True Crime. I was so happy to be gifted a membership because I can't work. My family has a modest income, but I suffer chronically. And so, yeah. So your Tumblr would really come in handy a whole lot because it's been several months. I would be ashamed to admit how long. But the goal is, so yeah, one of my Christmas presents was a foldable cane, yes, to give me some stability so I can start going to do stuff again. I live in Houston, Texas. I am a happily married wife. I homeschool our 14-year-old son, Ryan. He's my rainbow baby. And my question is, I want to know your story, just like, you interviewed with Chris and Karen. I want to know your story. Maybe you've already posted, I don't know. But yeah, I would love to know more about you. And Hi, Josh. This is Holly again. Now, this is not for the giveaway, but I ran out of time because I ran my mouth because I'm a Southern woman. Yeah, I'll be 50 slash forever 29 this late April. Yes. But I did not have time to thank you. This is the first website that actually accepts voice recordings. Um, one of my symptoms from my chronic conditions is trembling. I can type, well, excuse me, I used to be able to type like the wind, type very fast, no typos, all the things. But one of the symptoms is shaking and trembling, which is why it's very hard for me to leave my house because I'm just not steady. Um, and it also makes it near impossible to type. So that's how I best communicate with people. I use Facebook Messenger primarily because it lets me send voice chats. So I wanted to thank you. You have no idea how convenient and helpful this is, and how many times I have to step back and I don't reach out with creators and other people because it requires typing. So I just wanted to say a special thank you and let you know how much this means and how very cool this is for me. It really meets me where I am. So once again, thank you so much. Prayers that the giveaway goes great.
Wow. Holly, thank you so much. That is absolutely heart touching. Thank you. I don't know what to say. I kind of have my breath taken away by you being so brave to share everything with us. So thank you. And we appreciate you and we appreciate your support. And um, you know, that I didn't even think about the added benefit of these call-ins is that, you know, it might be more conducive to some folks. So thank you. Obviously, our heart goes out. Our prayers are going out to you. Please continue to check in with us and let us know how you're doing. Your question was about what is my story. I know you guys asked that. I've gotten that same question quite a bit. I appreciate that. We probably will do some sort of special episode where I'll kind of give you guys my entire background, but just to share a little bit, you know, what you probably know or don't know already. I am Southern California native, born and raised here in Santa Monica. I went to college at UCLA. I went to law school at Loyola here in California for a short stint where I lived in Chicago for about 4 years. I've lived my entire life here, met my wife here. I have 3 beautiful daughters. They are aged 4, 2, and 4 months old. So we are up to our gills in little ones at the house. But we have a house full of love. I was right out of law school. I went into the LA District Attorney's Office. I was a prosecutor, like I said, for 10 years. I loved that career. Met a lot of beautiful, wonderful people who are still my friends to this day. You know, many people went to my wedding, still a very huge part of my life. I left there after 10 years and went into private practice because I needed, quite frankly, I needed a new challenge and I needed to make some money. And the downside of working for the government and public services, you're not going to make a lot of money. And money wasn't the only reason behind it, but when you started to feel like your career was getting held up for bureaucratic reasons, I got frustrated and I said, let's see what other challenges there are out there. And I have loved every moment of being in private practice and all the things that it's opened up to me. I couldn't be doing this if I was still in the DA's office. So it's opened up a lot of new, exciting things for me. And, you know, one of those being that a year ago, we started this channel and it was an idea between Tiffany and Kaylin. And they turned to me and they said, we think you should do a podcast. And I said, I don't got time for that nonsense. And they said, well, we're going to make some time for you to do it. And I said, okay, fine. But if we're doing it, we're also putting it out on YouTube. And then before you know it, I'm saying, hey, I think we should add more content and I think we should add more shows. And what do you think about doing a Sunday show? And, so now here we find ourselves, and it's become nearly a full-time job for all of us. And we appreciate that we're now at 20,000 subscribers, and you guys are amazing, and all the support that you give to us. And it's exactly people like Holly. So Holly, again, love you. Thank you so much for sharing all of that with us. Thank you so much for your support. Really, really heartwarming, and really do appreciate you. All right. This is our last call.
Hi, Josh. This is Jen St. Peter, one of your biggest fans. I am calling because I work in the mental health field, so I understand HIPAA and FERPA and those confidentiality rights. But I was curious if there's ever a line where a lawyer would have to report you to law enforcement in the lawyer confidentiality clause, such as in social work. If you are at risk of harming yourself or others, I have to report. But I was curious where that line was for lawyer and client confidentiality. Thank you so much. I'm looking forward to Sunday Fun Day.
Jen, thank you for calling. Thank you for leaving a message. Again, a great question. So Jen's question is about essentially what are the limits of attorney-client privilege? All right, I'm going to put on my professor hat for a quick second here. First of all, the attorney-client privilege is probably, I think it is the longest existing on the books privilege, and it is one of the most closely guarded privileges. Privileges are about public policy and encouraging communication. In other words, there are certain relationships that, from a public policy perspective, we want to encourage the free flow of information between people, between a doctor and their patient. We don't want patients worried about some sort of criminal liability or civil liability by what they share with their doctor. If your doctor asks you, are you taking any drugs? You want to be able to tell your doctor, yes, I take the following narcotics, because it's important for the doctor to know that for your health. And you don't want to be worried that the doctor is going to turn around and report you to the cops for taking a bunch of illegal drugs. Same with your therapist. We want to encourage people to get mental health. And if that means that they talk about awful things that they may have done, that the therapist can hear that information because it's important for the therapist. Married couples, we want to encourage married couples to freely share information with each other. We don't want husbands and wives suspicious of what they can share with their spouse because they could turn around and tell the police. And of course, you could see how this all applies to attorneys. Probably more than anywhere else, the place where we want you to feel as free as possible to share some unfavorable, illegal, embarrassing information is with your attorney, and that should be protected. I tell my clients, you could tell me you've got a body in the trunk, and that is never leaving the four walls of this office. The other thing that's important to understand is every privilege has a holder of the privilege. So the patient is the holder of the privilege when it comes to the doctor. That's why a patient needs to sign a HIPAA waiver, to Jen's question. If they want to give their medical information and their reports from one doctor and hand it over to another doctor, they need to sign a HIPAA waiver, acknowledging that them as the holder of that privilege waive that privilege to give that information. And the client is the holder of the privilege when it comes to attorney-client privilege. So a client can waive that. They can say, I want my lawyer to say what we talked about. Or a client can go on the stand and say, here's what me and my lawyer talked about. But they also, being the holder, can affect the conduct of somebody else, being their lawyer. So they can prohibit their lawyer from giving a comment. if a lawyer were to be subpoenaed, not going to happen, but in this hypothetical scenario, subpoenaed and told, you need to turn over this information, and the client doesn't give a waiver or permission to do that, they are by law obligated not to do that. They could lose their bar license. Other problems could exist. That, I think, another thing to appreciate too, and I hope I'm not boring the hell out of you guys, but I find this stuff fascinating, is that privilege can extend beyond just the lawyer. It can extend to the defense team. So in other words, other lawyers in that same firm. It can extend to even investigators. Investigators need to know this information to be able to assist you in your defense. And it can extend to people illegally eavesdropping on attorney-client conversations. So in other words, if the government has your phone tapped and you call your lawyer and they happen to hear the information between you and your lawyer that doesn't somehow pierce that privilege, now that person, the person who heard that conversation, is under an obligation not to divulge it, okay? But like with any privilege, there are exceptions. The one we've already discussed is a waiver. They can say, I freely allow you to do that. I allow my lawyer to give that information. I allow my lawyer to testify. Or if the client just gets on the stand and opens their dumb mouth and starts to talk about attorney-client privileged information, and the lawyer either doesn't object or isn't quick enough to object, or somehow they open that up, now it's all fair game and they can talk about those attorney-client privilege conversations. Or if somebody in an attorney-client meeting is not part of that quote-unquote defense team. So many times I will have clients come in and let's say they are, husband and wife or child and parent, and I'm representing the child. I will say, listen, I'm going to ask you to leave for a moment so I can speak to your child, because I don't want there to be a question as to the attorney-client privilege protections here, because by you being here, that could say, well, this wasn't privileged. They could make an argument that wasn't privileged, and we want to know what was discussed. And then there are, I think, the questions that really Jen was asking of, when does a situation arrive where an attorney is compelled to break that privilege? The first is what's called the crime fraud exception. You cannot use your lawyer to further commit a crime. You cannot use your lawyer to advise you on how to commit a crime. There's an ongoing kind of, I'll give you a real life example. There's an ongoing kind of issue with marijuana dispensaries. In the state of California, the state law has made it legal to sell marijuana. Federally, it's still illegal. So we've got this weird zone where on the state side, it's legal. On the federal side, it's illegal, but the federal side doesn't really prosecute it. So you have a robust marijuana industry in California and in other states. But the firm I had been working for took a hard line on this. And when we would get many people who would come in and they wanted to open up a grow or a dispensary, and they had gobs of money and they wanted a lawyer. Help me walk through the intricacies of the legal system on how I can do this and not run afoul of the state laws. And we would say, our answer is short, it's illegal and we can't advise you. And we were probably more cautious than most, but we were told by our ethics attorneys that to advise them even how to follow the state laws is still advising them on how to break the federal laws. And so they need to fix that situation. But that is something you can't use your attorney for, is how to break the law, which includes crimes that you intend to commit. So in other words, a client can come into me and say, I killed somebody and the body's in the trunk. And that's attorney-client privilege, because that is a crime that has been committed, and they need to share that information with me. But if they say, and by the way, I'm going to go get that guy's cousin and throw him in the trunk as well, that is a situation that is not attorney-client privilege. And that is a situation where I might even be compelled to tell law enforcement about it, especially when it comes down to the next exception, which is preventing imminent death or harm. If ever I'm in a situation where I feel like what they are telling me, I need to protect the life or safety of someone else, I have to go to law enforcement about that. But I'll tell you another sticky situation that comes up all the time. I will get clients who say, could the government come get me if I lived in Mexico? Could the government come get me if I lived in Europe? While they have a pending case. And I, say the same thing every time. Let's not even go down that path. Let's not even start talking about that. And again, it's this weird situation of, I cannot advise you on how to break the law. I would be advising you on how to be a fugitive to the law. And I can't advise you how to do that. So I hope that answered that question. If you guys got any other questions on that, let me know. All right. Have we waited long enough? Do we need a drum roll, please? We had a giveaway for this time for the 20,000. It was a members only giveaway. Don't worry, we're going to be doing more giveaways open to every single subscriber. But for this one, it was a members only giveaway for this wonderful tumbler. And as Alicia K. Mayo, it says, with top and straw included. We took everybody who left a comment and chose one person at random. Kaylin, who's our big winner? Donna Barnes. Woo! Ha. Thank you so much, Donna. You are fantastic. You are wonderful. You've been a huge support of this channel. I'm so glad that you won. As you can see, Tiffany threw together a wheel there, and we chose at random, and Donna won. So congrats to Donna. Donna, email media@joshuaritter.com. media@joshuaritter.com, so that we can get your contact information and have this thrown in a box and sent out to you as soon as possible. I think you're really going to love it. It's one of my favorite items, like I said. But more giveaways to come. Not only do we reach this incredible milestone of 20,000, but next Sunday Fun Day, 2 weeks from today, will fall on our 1 year anniversary. Courtroom Confidential is turning 1 year old. So we're going to have a little birthday celebration, and we're going to do another giveaway, and we will send you more details about that and how to enter. And we will probably announce it at the next Sunday Fun Day. Again, we're not doing these every week for right now, because I have to find time to actually sleep every now and then, but we're doing them every other Sunday. So 2 weeks from now, follow the channel, keep your notifications on. I keep on being told to remember to tell you guys that. Put on your notifications so that you get all of these announcements. And we will let you know what you need to do to enter for the next giveaway. And I think we're going to do a really big one for this 1 year giveaway. So stay tuned for all of that. All right. We have gone quite a bit of time, but I feel like there's maybe a couple of more kind of updates that we can get into. All right. Let's talk about some stuff that was in the news that we did not have time to get into during the week, or some updates that occurred since we were in the week that I think you guys will find interesting. First of all, where is it at here? Okay. Diddy. Our friend Diddy. He's been having some issues. Poor Diddy. This is the most recent, like I said, superseding indictment that was filed against him. Oops, sorry about that. And it's interesting for a couple of reasons. First of all, it doesn't really change the charges against him. In fact, it absolutely does not change the charges against him. It's still 3 counts, but it added 2 new victims. And this is interesting to me. So let's walk through just a couple of the high points from this whole thing. I mean, and this, you can read the entire thing. I didn't want to take the whole time to do this, but I mean, there's allegations in here about kidnapping, about arson, about bribery, about hanging some victim over a balcony. That's believed to be Brianna Bongolan. Though she's not named in this, victim number 1 is believed to be Cassie Ventura. That again, she's not named in this. They're all unnamed victims. But this thing is just getting worse and worse and worse for Diddy. So a couple of highlights. First, here at the bottom of page 5. It outlines how Combs, I can't highlight it on this for some reason. Combs and other members and associates of Combs Enterprise wielded the power and prestige of Combs' role as the Combs business to intimidate, threaten, and lure female victims into Combs's orbit, often under the pretense of a romantic relationship. This is the first time we've seen this. The idea that he was using a romantic relationship as part of, according to the government, this overall theory, this overall scheme, I should say, to coerce people. Combs then used force, threats of force, and coercion to cause victims, including but not limited to 3 female victims, victims 1, 2, and 3, as I said, 2 and 3 are new, to engage in commercial sex acts. In connection with the commercial sex acts, Combs provided the victims with, among other things, monetary payments, career opportunities, and payment of rent and housing expenses. So this is all part of what is called the Mann Act, which is against the law against sex trafficking, which includes basically even a person moving across state lines for the purposes of prostitution. And why I highlighted this is this does seem to be getting into a little bit more of a gray area with the government. And again, if everything is to be believed, this guy is an absolute predator and a monster and horrible. I'm just going off of what's in this indictment here. And when I start to see things like under the guise of a romantic relationship and provided the victims with monetary payments, career opportunities, payment of rent and housing expenses, nothing's illegal about that. Monetary payments, career opportunities, payment of rent and housing expenses are all things that are legal to do. Do not turn that person from a girlfriend into a prostitute. And they have even described them as being in romantic relationships with him. Again, please don't start with the pitchforks at me, but Diddy's defense has said, how in the world are you now going to start charging him with people who he was in a relationship with? Again, this is just the indictment. It will all be fleshed out, but I thought it was interesting to see a little bit in a pivot in the government's way of charging this. And it goes on to talk about here, this is kind of throughout. Hold on. Oh, here we go. Combs subjected victims to physical, emotional, and verbal abuse to cause the victims to engage in freak-offs and other commercial sex acts. Combs maintained control over his victims through, among other things, physical violence, promises. See, again, I don't have a problem with the physical, emotional, and verbal abuse. I obviously have a problem with it, but that's strong elements of a crime. He maintained control over them through physical violence. That is a crime. But if you're going to try to say that this maintaining of control had to do with promises of career and financial opportunities, you're starting to get into a gray area where there's going to be wiggle room for the defense, is all I guess I'm saying here. When you start to make these more kind of less concrete arguments, you're giving wiggle room to the defense. Kraken Studio says, I explain it this way to people. A romantic relationship with financial gain or comfortability is not illegal, but the intimidation and mental and psychological abuses are in the alleged case. 100% right. In fact, maintaining a relationship with someone for even career opportunity, not illegal. Career advancement, not illegal. Removing career advancement from someone who's no longer in a relationship with you, not illegal. But if that is all being used to intimidate and mentally and psychologically abuse, as Kraken Studio points out, now we're drifting into illegal conduct. And my point, I guess, in reading this was one of the things that stood out to me was this idea that they are now in this umbrella cast by the government. They are now starting to include things that seem less concrete illegally to me. Obviously, physical abuse, mental abuse, sexual abuse, squarely illegal. Obviously, kidnapping, arson, hanging somebody over a balcony, obviously illegal. All of that, I think this case is very strong from what we're learning from the government. But when they start to open that net to include things like using career advancement, romantic relationships, these words begin to give me an uneasy feeling because I wonder, are they now starting to overreach in what was otherwise an incredibly strong case? Last takeaway from this, the government ain't done. They are continuing to convene the grand jury. That's why we have this superseding indictment. They are continuing to go after him. They are continuing to interview people. They are continuing to get people coming forward. This might not be the last superseding indictment. They may continue to go after this man, and it's just going to get worse and worse and worse for him. And that might be heading to trial this year. And I really do feel that Diddy is never going to see the light of day again. It's a very, very serious case. All right. Any other questions on that? And then we'll move on to Marilyn Manson. And then I want to, before we go, the last thing I do want to touch on is the Greenberg case, because something really fascinating happened with that. So make sure you stay to the end. Then we got some announcements and things. But Lee T says, could the government added the relationship part to further show a pattern of behavior? I think why did they added it is they don't want him, for the same reasons that I say it's gray. They don't want him to escape culpability merely because he made the situation gray. In other words, it's not mutually exclusive that you have a relationship with someone that you're also prostituting, that you're also trafficking. They don't, one does not make the other invalid. He could have had a romantic relationship with these people and still traffic these people and still paid for them to have sex with others and paid others to have sex with them. All of this being illegal, all of this being abuse, all of this being without that person's consent. And they're saying you don't get away with it just because you happen to also take the person to a dinner party here or there. And I agree with that. And so I applaud their efforts in that. I'm just saying it's going to then allow for the defense to make certain arguments. All right. Great question, though. Let's see. Mama She, thank you so much for the question and the contribution. Sad that I wasn't able to chat today, but I feel like I've learned so much. Thank you. Oh, well, thank you for saying that and for sharing that with us. And I'm glad that you were able to do that too. I'm glad that you learned so much too. I appreciate that. Sometimes I feel like I need to shut up, but I'm glad that you guys appreciate some of the stuff I have to say. All right. Marilyn Manson, another one that was in the news, kind of breaking stuff that happened towards the end of this week. But Marilyn Manson, whose real name is Brian Warner, I don't know why that cracks me up. He was under investigation since 2021. His accusers included Westworld actress Evan Rachel Wood and Game of Thrones actress Esme Bianco, so some big names that we've all heard of. And they basically said that he both committed domestic violence and sexual assault against them. The Sheriff's Department executed search warrants on his home in 2021. One other interesting thing to add to all of this is that this was not the first time he had been accused of something similar to this. In 2018, under District Attorney Jackie Lacey, they declined a case because they felt that there was not enough proof. And that's what recently happened now. Nathan Hochman, the current DA, declined the case, saying that, one, the domestic violence charges were past the statute of limitations, which likely meant that whatever was being alleged or that they could prove they felt was misdemeanor conduct, and therefore fell outside of the statute of limitations, or it was felony conduct, and when it took place was before their investigation and therefore still fell outside of the statute of limitations, and that the sexual assaults, which have a longer statute of limitations, they just did not feel there was enough evidence. The reasons provided by the DA who rejected it was that the victim was acquainted socially with the suspect. That's not the only reason, but one of the reasons they provided, and the absence of corroborating evidence. And the reason I wanted to bring this up and why I highlight those two reasons is I think they really showcase the incredible difficulty with filing these types of cases. Domestic violence, sexual assault, they are crimes that take place in the dark. They are crimes that take place behind closed doors. They are crimes that do not leave, oftentimes, corroborating evidence. Injuries, sure. Corroborating evidence, absolutely. But what if there's not the type of injuries that we would expect? Or what if by the time they're reported, the injuries are all gone? What if by the time they're reported, the opportunity to test and evaluate something on someone has passed? Oftentimes, these are not reported immediately. Oftentimes, the person's afraid. The person's still in shock. For whatever reason, they don't come forward. And by the time they do come forward, all physical evidence may be lost. All surveillance evidence may be lost. There may be little way to corroborate this. And no one is saying that these women cannot be believed. No one is saying that he may not have committed something. What they are saying is that they don't feel that they can prove it beyond a reasonable doubt. And that's why they're not bringing the charges, which again shows you how difficult these cases are. There's a case that is currently being deliberated here in Los Angeles, People versus David Pierce. We've talked about that a few times on this channel. He is accused of assaulting these two women, Hilda Cabrales and Christy Giles, and leaving them at separate hospitals where they ended up dying of drug overdoses and fatal doses of fentanyl. And the reason I point that out is that the reason this case is being brought and why it's strong and why I think it's going to lead to a conviction is it wasn't just against these two women that he's being charged. There were 7 prior women who survived who said they were also sexually assaulted by this man with the use likely of drugs or some sort of intoxicant. That is a wake of people. And it just goes to show you how many of those cases didn't get filed, were rejected. The women were too afraid to come forward. And it took 7 different women and now 2 dead women before he's actually brought to justice. Again, is this symptoms of a broken system? Perhaps. Is it also just how difficult these cases are to prove? Absolutely. Sam, I believe they are deliberating. I believe that they got the case on Friday. If you guys know better than me, I should probably know, but I believe that they got the case on Friday, and they may have started deliberations a little bit, but I believe they're going to be deliberating in full on Monday. All right. Now, our last update, and this is the real kind of kicker that made news. This actually happened yesterday. You guys may know about, may have heard on this channel. Joel Waldman from STS has done a lot of work on this case. This is about Ellen Greenberg. Beautiful woman. She was a 27-year-old school teacher from Philadelphia. And in 2011, she was found stabbed 20 times in her head and neck. And it was believed, or not believed, ultimately ruled by a medical examiner to be self-harm, to be suicide. And people obviously, and Kaylin, if you have that diagram, obviously just, you don't have to be a forensic pathologist or crime scene reconstruction expert to take a look at these injuries and say, that to me does not seem like the way that somebody would take their own life. That to me seems like that person was the victim of a murder. She was discovered by her fiance, Sam Goldberg. And Sam has fallen under a lot of internet suspicion, and a lot of people believe that there's a lot that did not add up about his story. But for, over 10 years, the close to 15 years, the family has gone completely frustrated in that this case remains classified as someone who took their own life. Well, they recently had some new analysis done. The family has not let up about this. They have continued to try to fight this case, and they filed a lawsuit against city officials for intentional infliction of emotional distress. It's a civil lawsuit. But what they are saying is that the mishandling and even what they allege to be a cover-up in this case has led to so much emotional turmoil and distress that they should be awarded damages. These people are obviously not after money. These people are after the truth. And I think that they feel, given that the police and the DA's office won't take action on this, and there was an announcement that was made where they said that they have now considered the case to be not closed, I think is how they put it, which read that however you want, but some have read it as that they are no closer to bringing a filing that they were before. And other people have read it as, well, that means that they're still openly investigating it. But I believe that the Greenberg family felt that the best opportunity for them to get a lot of this out in the open and cause some movement on this case was to bring this lawsuit. That lawsuit begins jury selection tomorrow. So the judge allowed it to proceed. They're going into court tomorrow. Yesterday, Dr. Marlon Osborne settled with the family. He was one of the named defendants. He settled. Oops, hold on. And part of his settlement was that he released this. It's being titled a verification, but to me, I read it as an affidavit. Starts out with, I am a resident of the state of Florida and maintain a medical practice at, such and such street in Florida. I am a licensed physician in the field of pathology in Florida, blah, 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 blah. All of this goes on and on and on. It's only 2 pages long, but here's the real meat and potatoes of this whole thing. He said on January, I don't know why I can't highlight these things. On January 27th of 2011, I performed an autopsy of Ellen Greenberg, deceased, to determine her manner of death to be homicide. His initial autopsy determined the death to be homicide. I signed a death certificate in it indicating the manner of death was homicide. I thereafter issued an amended death certificate on April 4th, so 4 months later, for Ellen, which changed her manner of death from homicide to suicide. This change was based on an additional evaluation of the case file, additional information provided to me by the Philadelphia Police Department, and a neuropathology consult I secured from Lucy Rourke Adams, MD. Okay, that bothered and shocked a lot of people. Why are the police getting involved? Why are they trying to affect this medical examiner? Why was all of this changed? Let's just take a deep breath for a moment and realize if a medical examiner receives more information and that information leads them to believe that their original assessment of this was wrong, I think they should be encouraged to change that. Think about it if it had gone the other way. If he originally evaluated this and felt it was a suicide case and then received other information that clearly supported the idea that it was not, that it was a homicide, I would want a medical examiner to feel free to amend that. So the amendment of it is not a problem. The medical examiner's amendment. Where people really dug in and started to have a problem is why? Why is the police department getting involved in this? Why are they asking him to change it? And why are we not being provided with a reason for that when we look at that photo and it appears to anyone who's walked this earth that something untoward took place there? Then he goes on to say, since issuing the amended death certificate, I've become aware of additional information I did not have at the time of issuing the amended death certificate, which may have impacted my opinion. So this poor guy, if he's to be believed, he's just been ping-ponged back and forth with information here. I am now aware that information exists which draws into question, for example, whether Ellen's fiance was witness entering the apartment before placing the 911 call on January 26, 2011. In other words, this to me is information that was provided to him in support of the suicide evaluation. Whether or not he was given accurate information on that or even learned of that information may be a problem. So now we're starting to wonder, was he given bad information, half of the story, or no story that had him changing his original conclusion of homicide to making it a suicide? Whether the door was forced open as reported. As reported. In other words, now he believes he may have information that calls into question the reports. Whether Ellen's body was moved by someone else inside the apartment with her or near the time of her death. Again, and the findings of Lindsay Emery from the neuropathological evaluation of Ellen's cervical segment sample. But these first few points here are really mind-blowing. That one, either this medical examiner did not have that information to begin with, which is a big problem. Or two, he had the information, but it wasn't all the information, which is a big problem. Or he was given false information, which is, any way you look at it, the fact that we are close to 15 years later, and this guy is now for the first time saying, I'm learning new information that is causing me to change the way I see this case again, is a problem. Now, the one weirdness about this, and I think this more had to do with civil liability than anything else, because remember, this is still in relation to a civil case and him getting dismissed as a defendant, which bolsters my point that this wasn't about money. It was about getting to the truth for the family. They were willing to drop their case against him based upon this. Is he says, it is my understanding that I'm no longer empowered to amend Ellen's death certificate because I no longer maintain a Pennsylvania medical license and am no longer employed by the Philadelphia Medical Examiner's Office. Okay, fine. Based on my consideration of the new information brought to my attention after leaving my position as medical examiner for the city of Philadelphia, along with my original autopsy findings and information considered while I was actively involved in Ellen's case. Here it is. It is my professional opinion Ellen's manner of death should be designated as something other than suicide. That's mind-blowing. That is shocking. That is ground shaking. And it is going to be exhibit number 1 in this lawsuit that's about to begin tomorrow. But why didn't he put what manner of death? I think that has to do with kind of him carefully wording this and what kind of civil liability he may be subjecting himself or others to. But it's so funny to me when he says something other than suicide. Well, the only things it could be is natural. No. Accidental. Don't think so. Or homicide. So it's either a homicide or what we just call undetermined. And maybe that's where he didn't want to get caught up. Does he declare this undetermined and will that cause more trouble? Does he declare it homicide? Will that cause more trouble? Or does he just say it's not suicide? We know it's not natural. We know it's not accidental. So therefore, it falls into the arena where it could, the point is, whether you call it homicide or you say it could be homicide, it opens the door for further investigation and developments on this. And this lawsuit may expose more of that. So really crazy development in that case. I'll be honest with you. I've been hearing, especially Joel on SDS, talking about this case for a while. And I don't know if it was just the cynical part of me or what, but I just kind of thought, you know what, don't expect much to come out of this. Sometimes crazy things happen. Sometimes there are mysteries in life and they never get solved. Don't expect this case to ever really have traction after this many years. And boy, was I proved wrong, because this is definitely some movement and definitely some traction. And we might be getting more out of this whole case. All right. Do we got any questions before I let us go? Why should he need to consider anything outside of his own observations? No, he absolutely should. The things that he would consider are, the autopsy is just considering the body. And if all you have is a body, and let's say it's got a gunshot wound to the side of its head, part of the medical examiner evaluating whether or not it's a homicide or suicide is, well, the gun was recovered from the victim's hand. Oh, that might lend itself towards self-harm. Or the gun was recovered 12 feet away from the victim. Oh, that might lend itself towards homicide. So yes, you want the medical examiner to have other information. They're not the ones solving the crime, but they might need other information to evaluate on whether or not the manner of death can be determined. Cause of death, you can do from the body alone. Manner of death, you need some surrounding circumstances to understand. Great question, though, K9. All right. Crazy stuff. You guys are awesome. The questions were awesome. Next time, I'm going to bug you guys and I'm going to bribe you guys and I'm going to harass you and I'm going to make you work up the bravery to leave us even more questions, because I would love for the whole show to just be your questions rather than me blathering on. Kathy, thank you so much for becoming a member. Mama, she became a member. You're fantastic too. How, which raises the question of how do you become a member? Well, we've made it easy for you. If you just go to our website, thecourtroomconfidential.com, and click on this button right here, become a member, it's going to shoot you over to this page where you'll get all the information about becoming a member. You can click on this button and join the CC crew. If you've got questions on, I know that you guys are dying to know, how can I leave a voice message? Josh, that was so much fun to hear all the voice messages. How do I leave a voice message? You click on over here, this button that says send voice message. And this little prompt will pop up for you and you can start recording and tell us Josh, you've got it all wrong. Josh, you've got it all right. Here's my question. Thank you so much for everything. Whatever you want to tell us, love to hear from you guys. And also, you can click on our shop and see all of the merchandise that we offer, including this tumbler that we just gave away today. So thank you guys again. I hope that you have a wonderful, wonderful Sunday. I am so incredibly appreciative for reaching this milestone of 20,000 subscribers. Tiffany sends her love. Kaylin sends her love. We appreciate all you guys and what you have given to us, and that's why we want to continue to give you guys as much as we possibly can. Pammy, thank you so much for the gift of new memberships. Queen Olive, thank you so much for becoming a member. Catherine, K9 Catherine, thank you so much for the gifts. Yeah, let's run through everybody so I don't miss anybody. Kaylin, Kat, thanks on the congratulations. Anna Lee, thank you for the super sticker. CJ, thanks, CJ. Let's get to 50,000. I like it. Gen X to the 7th power. Thank you for the super sticker. Kraken, thank you for the gift of memberships. Tracy Fagan, can you do a show with Andrea on Brian Koberger? Oh, yeah, that's a great idea. I know that she's following that case closely. Joy W sends a super sticker. You're fantastic. Tracy, thank you for becoming a member. The next giveaway, we're going to send you more details, but it's obviously going to involve a voice message. So just get past it. I get a lot of you guys saying that you want to leave a voice message, but you're too nervous. Well, have a shot of whiskey and work up the nerve. Serenity RPH, thank you so much for becoming a new member. And Tiffany's yelling at me. Tell them how to enter. We're going to give you guys more details. It will include leaving a voice message. We will let you know more about what needs to be done. This is in celebration of our 1-year anniversary that is coming up in February at the next courtroom Sunday Fun Day, 2 weeks from today. In the meantime, have a wonderful rest of your Sunday, everybody. Thank you so much for spending the time with me. You're all fantastic, and I appreciate you all. Take care.